that the premises upon which these proceedings are mounted must be supported by the law. And therefore, at the particular time of commencing the proceedings, this court is not restrained from interrogating the conditions president. It has been highlighted before Your Honor the transgressions that befell our client before, during, and at the time of the arrest. The court is invited, Your Honor, to interrogate whether there was whether there was compliance with the Constitution, not violation with the Constitution, but compliance with the Constitution. I am laying emphasis on compliance and distinguishing it from violation because I know my learned friends will go to the Magistrate Act and pull the magical Section 8. But that's not what I'm saying. I am inviting the court to look at the application of the Constitution. And that question, Your Honor, of the application of the Constitution has been dealt with by the Supreme Court in the case of Hussein Khalid versus the ODPP, Supreme Court petition number 21 of 2017 at paragraph 23 and 24.
Repeat.
Supreme Court, Hussein Khalid versus the AG, Supreme Court petition number 21 of 2017. At paragraph 23 and 24 of the judgment, the Supreme Court...
I'm recording word by word.
Oh, yes, sir.
So the way you speak.
I beg your pardon.
So you say...
May I take it again?
Yes, repeat.
Hussein Khalid versus the Attorney General and others of the ODPP, Supreme Court, petition number 21 of 2017. Of our interest is paragraph 23 and 24. In those paragraphs, Your Honor, the Supreme Court distinguished between
paragraph
23 and 24. The Supreme Court distinguished between the responsibility of a court of law to apply the Constitution and to interpret the Constitution. There was a distinction. And the Supreme Court indicated that the responsibility of the interpretation of the Constitution vests with the High Court, while a magistrate court such as this one can apply the Constitution. And of course, the Supreme Court, Your Honor, was coming from Section 20. Sorry, Article 20, Your Honor, Clause 3, where it provides that in applying the provisions of the Bill of Rights, a court shall. The Constitution does not define the jurisdiction of the court. It merely provides the court shall. And for the court, for these purposes, therefore, means even this particular court established under this Constitution. And you are told, Your Honor, when applying the Bill of Rights, and again the law, the article provides the word applying, not interpreting. In applying the Bill of Rights, a court of law shall develop the law to the extent that it does not give effect to the rights or fundamental freedoms. So when you are applying this provision, Your Honor, even upon the basis upon which this prosecution was mounted, you are invited to apply the law and see whether there was compliance. If therefore there was no compliance with the law and it is so dictated that there must be a compliance, the question therefore would be, if the garbage in, or is it garbage out? If we have put in garbage, can we get any good end results at the fullness of time? Yona, you might want to look at that charge sheet that has been brought before you. You are told that our client ought to take plea for offensive conduct conducive to the breach of peace. And the conduct is as a consequence of his utterance. And you are told, Your Honor, that there was an interpreter who has interpreted the language from Kikuyu language to English language. Your Honor, we need to look at that propriety of the interpretation itself. And why is it important, Your Honor, before I come to that? Is because Article 50, Clause 2, invites you, Your Honor, Clause 2, Paragraph B, provides that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient details to answer to it. The place where you find the information of a charge is in the particulars of the charge. Therefore, the particulars of the charge must be able to communicate in a manner that the accused person understands the charges that he faces. And Your Honor, granted the fact that we have only 2 languages in this country, English and Kiswahili, the interpretation must conform and must inform the accused person of the particulars and the ingredients of the charge. If there is any distortion, Your Honor, then there cannot be a charge to which the accused person can answer to. And although this is a new field where the court needs to interrogate and explore in its effort to develop the law, when an interpretation such as this one is done and is not accompanied with a certificate, how shall we know that the interpretation from Kikuyu language, the English language, captioned the actual words that are deemed or perceived to be offensive? I know the ODPP will say that the Criminal Procedure Code does not allow them or action them to accompany a certificate. But again, we are told to develop the law. And the reason why you are told to develop the law, Your Honor, is so that you can implement this strict adherence to the Bill of Rights. Such that, Your Honor, if our client was to respond to the charges, it must not amount to a violation of his rights and Article 50. This is one of the unique cases, Your Honor, where such a certificate is required to make sure that the accused person understands the charges facing him. You know, I have the benefit of understanding the language that is deemed to be offensive, the Kikuyu language. I equally have the benefit of understanding the little English from my school. And you can see clearly the difference. For example, the words deemed to be offensive have used the word Kasongo twice. If you go to the interpretation, you'll only see the word Kasongo once. Where did the other one go? And was it material? Number 2, Your Honor, I'll refer you to a thesis.
I warned you that I must record.
I beg your pardon?
The way you speak, be systematic so that...
am I too fast? I'll take it again, Your Honor.
So
I beg your pardon. Your Honor, I had indicated that we are looking at the propriety of the charge and the ability of the accused person to understand the charge.
Start where you are trying to interpret the two
I beg your pardon?
languages.
Oh, yes, Your Honor. So I was indicating, Your Honor, that I have the benefit of understanding the Kikuyu language and the translation, and I credited my English teacher for that. But I said, Your Honor, that if you look at the interpretation, the English interpretation, it has applied the word Kasongo once, while the Kikuyu version has applied the word Kasongo twice. And then you are told that the reference to the word Kasongo amounts to an offense, and it is bordering between the breach of peace, when the same is not definitive. Subsequently to that, Your Honor, just to show you how tricky it is and how careful we need to be in this interpretation, I wanted to refer you to a thesis that was done by Dr. Mwaneki Isaiah Ndungu for his PhD. It's titled The Pragmatic Limitation of Translation and Interpretation of First Language Utterances into Second Language. Of the most importance in that particular language, the good professor indicates the risk that you run in the interpretation. I refer you to, and I'll offer this book to you even for your library, at page 6, the statement of the problem and significance of the study. He says, and I just quote, and I hand over the book to you, and I'll also have given it to the prosecution. This begs the question whether the translated and interpreted version of the speech in an ethnic language into English is done in a manner that is socially acceptable and legally appropriate to sustain criminal charges against the presumed offender. You know, you'll have this benefit. Why that thesis, Your Honor, is important for you to have a reference to is to guard the chances of abuse. By the prosecution, and most importantly, the intention to gag. Finally, Your Honor, yesterday when we went to the police station with my colleagues, and we had the benefit of looking at the entry in the OB at Kamukonji police station, the accused person had been, it was alleged that he had violated section 10, subsection 3 of the Election Offences Act. That is the first initial entry of the OB. Today, Your Honor, and just to show you the malice behind this process, they have brought you these charges. I know the OB is not before you. This is for your benefit, Your Honor. So that, Your Honor, a court of law, as indicated by my line friend Mr. Kirago, should not be a conveyor belt just to take anything comes. And the ODPP cannot just say that Article 157 allows him to charge any other person and should not be questioned. The only safeguard we have against the arbitrariness and the mighty ODPP is the court. So that your pen, Your Honor, may gag the mighty ODPP. So that the mighty ODPP, Your Honor, will not exploit the benefits of Article 157 to bring flimsy and trump-up charges before you. The only person who can control the weight of the mighty ODPP is you. Your Honor, this morning, as I pen off, I have the benefit of mentoring one John Medho, the senator for Nyandarua County, who is undertaking his law degree at Nairobi University second year. And I have the benefit of having him before me and promising to be his good people master. Thank you, Honor.